We're good. Thank you, everybody. Thank you, and welcome to the New York Hemp Industries Association webinar, New York's New Hemp Laws Explained. We're very, very excited to provide this information and just so proud of New York and our legislators. I'm Joy Beckerman. I am the president of the National Hemp Industries Association, founded in 1994, the nation's premier hemp trade association. We just had our 26th annual conference, HIA Con. We serve just about 2,000 members, and I'm very proud to be the founding president and now secretary of the New York Hemp Industries Association, the New York State chapter. And it's my great honor to introduce our president, Aidan Woishnis.
Nice to meet you guys virtually.
He's not only our MVP, but he is also our technical guru. So Aidan will be going back and forth dealing with some technical stuff, and he's also going to do some narrating as we explore this bill. A couple of things. In terms of joining the Hemp Industries Association, please feel free to go to joinhemp.org. I know our website there is a little covered by the easel, but joinhemp.org. You can join the New York State chapter for free when you join the Hemp Industries Association, and we have multiple levels and tiers and types of members. And especially if you're from New York, we want you to join us. We just seated our new full board. We have been operating on an interim board. We're a new chapter, and we've just seated our full board and are about to have our first strategic planning meeting in Albany, and are just very excited to get committees going and to help build the hemp economy here in the state of New York. And that brings me to people we need to thank. We've had tremendously robust hemp laws here in New York. New York has been leading the way, and very much thanks to Assemblywoman Donna Lupardo in particular, who is also the chair of the Assembly Ad Committee. She has been a hero and an advocate for this versatile, valuable plant to reclaim its place in the broad light of day with America's other agricultural commodities in New York and throughout the United States for several years. She, in conjunction with, of course, Senator Jen Metzger, who is also the chair of the Senate Ad Committee, and the governor's office, in particular, the Governor's Council on Health, Axel Burnaby, have taken our program and brought it to the next level and have really listened to the amendment requests and the concerns of farmers and industry stakeholders throughout last session and through the summer. Multiple groups have worked with our legislators, particularly the Hemp Industries Association and the NYHIA, has worked with Assemblywoman Lupardo and Axel Burnaby for over a year. And this is really what the bill that was just signed into law, the agreements, the amendments that were made from the temporary law that was passed at the end of the session last year, really demonstrate how much our legislators and our governor's office are listening to our concerns. The Hemp Industries Association basically got almost every amendment request that it asked for granted. And I know that we shared a lot of those amendment requests with other groups, the U.S. Hemp Roundtable and others. And we'd also like to thank the U.S. Hemp Roundtable for their advocacy, very effective advocacy efforts here. The credit goes to our legislators and our governor's office, particularly, again, Governor's Council on Health, Axel Burnaby, for working so beautifully with the concerns and the complexities that were brought to them by stakeholders and farmers. So without further ado, I'm very excited to share this law with you. The bill that was passed is Assembly Bill 08977, and of course it has a Senate sister bill that was identical. So let's get started with it, folks. And so you know, we will have, of course, a question and answer period at the end. I'm not sure how long it will take us to go through the bill. There were some sections that we actually want to read as well as explain, but you will please hold your questions to the end, and we'll be happy to address every single one of them. We'll keep going as long as we need to, and folks can end their session as they need to as well, of course. So I'm going to share my screen. Let's see here. So hopefully now everyone is seeing the law itself, and maybe a little corner of their screen is Aidan and I. Now the law is divided into two sections. one section is specific to the New York Department of Ag and Markets, and it deals with the cultivation of hemp and no processing whatsoever, just the cultivation of hemp, although it does also deal with, as we'll look at it, processing in conjunction with the cultivation of hemp. And then the second section, which has to do with the public health law and amending the public health law, and talks about the Department of Health, which, if we're not able to create a separate brand new standalone agency here in the state of New York, which would be known as the Office of Cannabis Management or Office of Cannabis Law, then the Department of Health will indeed be governing our cannabinoid hemp products, the processing, retail sale, and other aspects of our hemp extract products. So that's why this bill is divided in two. The first section amends the agricultural laws, agricultural and markets law, and the second section amends our public health law. And with that, let's talk about the amendments to our agricultural laws, where we talk about the growth of hemp. And we see here all of the different sections, like every bill has a little table of contents with the different sections, and then we'll move down to discussing them. And there are certain definitions that I would like to read out loud. I apologize if any of this narrating becomes tedious. I promise we won't be reading every aspect of the bill, but I think some of them are pretty important. So may I impose on you, Aidan, if you could go ahead and read us the definition of hemp, and I'm going to explain why it's so significant.
Okay. So hemp means the plant Cannabis sativa L, and any part of such plant, including the seeds thereof and all derivatives, extracts, cannabinoids, isomers, acids, salts, and salts of isomers, whether growing or not, with a delta 9 tetrahydrocannabinol concentration of not more than 0.3% on a dry weight basis.
And why is that definition significant is because it A, duplicates the federal definition word for word, and by the way, foreshadowing here, spoiler alert, we're going to look at how different that definition is and why it's different and the differences are good in the next section. But here, this duplicates the new federal definition of hemp, which has included and freed every single part of hemp from the Controlled Substances Act, including the seeds, the viable seeds, the derivatives, extracts, and cannabinoids. We really needed that to happen to truly extricate again, this versatile, valuable, safe plant from the shackles of the Controlled Substances Act. And of course, no form of cannabis belongs in the Controlled Substances Act, certainly not hemp. We then go on to describe institution of higher education, and that is specific to our research partners and other research that the state of New York and our research universities are going to want to do on hemp and perform on hemp. And we've expanded the definition of institution of higher learning, of higher education here in the state from the federal definition, which I think is great. We then go on to define license. It's a license issued pursuant to the article to permit the growing, which we'll talk about here. And this is a very interesting definition that I want folks to take a look at. And that is the definition of a term called processing of hemp in connection with its growing and cultivation. And that means the growing, the cultivation, as well as cloning, harvesting, drying, curing, grinding, and trimming of hemp plants. So all of those activities are defined within this term called processing of hemp in connection with its growing and cultivation, as opposed to processing of hemp not in connection with its growing and cultivation, and that will reveal itself as we further explore. Now, we get into the first section of the bill itself, which is titled The Growth, Sale, Distribution, Transportation, and Processing of Hemp and Products Derived from Such Hemp Permitted. And basically, what this is saying, actually, this is a pretty important and powerful one as well. If you wouldn't mind, Aidan, to go ahead and read that particular one, starting at line 27, notwithstanding.
Notwithstanding any provision of law to the contrary, hemp and products derived from such hemp are agricultural products which may be grown, cultivated, produced, processed, manufactured, possessed in the state, and sold, distributed, or transported in the state, pursuant to an authorization under federal law, provisions of this article, Article 33B, and the public health law or any other state law.
And when they talk about Article 33B of the Public Health Law, that's the second part of this bill that we'll get into. That's Article 33B. So as long as we have an authorization under the feds, which means that the federal government, once New York submits a state plan to the USDA for hemp as an agricultural commodity, that authorization, and then as long as you are licensed or acting in compliance with this article, the law we're talking about now, or the next article in the second part of this law, or any other state law that's allowing this, we can grow hemp, we can process hemp, we can manufacture, sell it, distribute it. It has been liberated in the state of New York. And when I say liberated, though, keep in mind, it still needs to be licensed. And one thing that I'll just say right now, because it's not addressed in the law, but some of you may be curious, for the 2020 growing season, the state of New York is opting to continue to operate under our agricultural pilot program. In other words, operating under the 2014 Farm Bill. The state of New York will not be urgently submitting a plan to the USDA for approval under the 2018 Farm Bill. We, like other states, Kentucky being one, are choosing to operate and continue to operate under the 2014 Farm Bill for the 2020 growing season. There are certainly multiple flaws within the USDA's IFR, or interim final rule, on the domestic hemp production program, which the USDA filed on October 31st. As many of you may be aware, on January 29th, the public comment period on that interim final rule ended. The HIA and the New York Hemp Industries Association entered 14-page, very articulate, very upset, frankly, but also persuasive comments. And we can get into that a little later on IFR if folks ask questions about it. We'll stick to the New York hemp law, but to understand that there are in fact so many flaws in the USDA's interim final rule that New York and other states have chosen to give that a year to hopefully heal itself, and that very necessary amendments will be made to that. And then at that point, New York will feel comfortable submitting a plan to the USDA. It's important to note that the provisions under the 2014 Farm Bill, the federal bill, will be repealed, meaning they will dissolve and go away and no longer exist as of October 31, 2020. So these states, including New York, of course, have until that time to ride it out. There may be, it's true, some folks in New York still harvesting after October 31st, but we'll deal with it at that time. New York, as always, is giving its farmers cover and protection to the best it can, to the best of its ability, and that's what it's doing by not submitting a plan to the USDA right away and allowing our program to continue to operate under the agricultural pilot program of the 2014 Farm Bill. Okay. So back to our Assembly bill and Senate bill, sister bills that were passed. Now, additionally, this bill, and we're now in section 2, or part 2 of 506. And here, what it basically talks about is that the commissioner will be able to may, and that's different than shall. So keep in mind, when we say may, our legislators have very intentional reasons for using the may versus using the shall. The shall is a command, and the may is giving options. So the legislators are now giving the commissioner of the Department of Ag the option to authorize the growing, cultivation, processing, and manufacturing of hemp as part of agricultural pilot programs conducted by the department or an institution of higher education, to study the growth and cultivation, sale, distribution, transportation, processing, and manufacturing of such hemp and hemp products. provided that the sites and programs used for growing the cultivation of hemp are one, authorized by and registered with the department, are authorized, and registered by the department. Again, there will be no growing of hemp in the state of New York without it being licensed or authorized by the department. Also, the commissioner may and is being given the option to license the growth and cultivation of hemp, including processing of hemp in connection with its growing and cultivation, and the sale of hemp plants or hemp seeds. So all of this will be under the jurisdiction of the Department of Ag, except that which will be under the jurisdiction of the Department of Health, and we don't learn about that till we get to the next section of the bill, the Article 33B part. Now, Section 507 of this first part are prohibitions, and so they want us to know that unless authorized by federal and state law, this is not an either or, unless authorized by federal and state law, and the rules and regulations promulgated thereunder, so federal rules, federal law, state rules, state law, the growth, cultivation, sale, distribution, or export of hemp is prohibited here in the state of New York. Understand that that's not, folks like me may split hairs and get paranoid. I've been doing hemp for 30 years. I should probably, many of you I think do know me, but perhaps I should also say that I am an expert witness and have a legal consulting firm, Hemp-Based International. I owned the first hemp store in the early 90s in the state of New York in Woodstock called Heaven on Earth. I'm also the regulatory officer and industry liaison for Elixinol, a hemp extract company in 50 countries. I am part owner and senior advisor to the nation's first post-prohibition hemp grain processing facility. I tell you these things only so that you have some context when I say things like, after 30 years, I read law and regulation and my porcupine quills go up. My psychic porcupine quills go up because I think something unfair is happening. And I want you to know that I have 10 ways from Sundays, read through this bill and sought clarifications from our legislators and from Axel Burnaby. And I can tell you that this prohibition is not meant to be overly broad or overly inclusive. There are many state and federal authorizations that allow, particularly, of course, mature stocks and all of those fiber, all of those raw materials, sterilized seeds, and all of those materials. You know, those have been in interstate commerce forever. They've never not been legal one day in the history of the United States. So this is prohibition section is not overly broad. They're just making it very clear that folks need to be aware of laws and complexities that govern various aspects of the hemp trade. This is also very important. Hemp produced outside of the state, very important right here, guys. Hemp produced outside of the state and sold or distributed in the state shall meet all standards established for hemp under state law, rules, and regulations. So if you're going to deal with hemp grown outside of the state, you're going to deal with hemp products produced or processed outside of the state, they're only going to be able to be sold and distributed in the state of New York if they meet all of the standards established for hemp under our state law, which is very important to the state of New York. We want, of course, standardization, frankly, in all of these aspects, all states to have the same standards for labeling and marketing and all of that. But since we, particularly when we get into hemp extract, there are complexities involved. That's not always happening. So we have no choice but for the states to come in and implement their labeling standards, their marketing standards, so on and so forth, their growing standards, and then we have to protect our own state. So New York is saying, hey, and in previous bills, they weren't allowing anything from outside the state significantly to speak of. That has changed. Those amendments have been granted. But New York is certainly saying, if you are going to sell or distribute it in the state of New York, it's going to have to meet our standards. And that's very important. And then, of course, it goes on to state that the commissioner is authorized to promulgate and amend and issue rules consistent with the article. Let's move forward here. There is some when I am going to want Aidan to go ahead and read, but in the interest of efficiency here, so we can keep moving on, because the hemp extract one is where it gets a little bit more complicated and we don't want to use everybody's time unwisely, that obviously the authorization or licensing of any person who may acquire or possess hemp plants or viable seeds, grow or cultivate hemp plants, or sell, purchase, distribute, or transport such hemp plants, plant parts, or seeds, the commissioner is freed up to authorize them. They also are going to set reasonable licensing fees and duration of license, which shall be at least 3 years. There's a couple things I want to point out here, guys. The use of the word reasonable throughout this law is very impressive, and we do need to give our kudos and thank our legislators and the governor's office for deliberately using the word reasonable so much throughout this law. We don't see that very often, and that was also an amendment request that we made. We don't see that in law. There's usually a lot of hysteria, whether it's around THC phobia or it's a non-liberal state. There's usually a lot of hysteria around hemp and hysteria in the language of the law that allow them to set fees. And then some states set completely unreasonable fees. But here, our legislators recognized that they wanted to make sure there were checks and balances and guardrails in place. And so they do use the word reasonable a lot. So when you hear me say that, it's sort of like a ding, ding, ding. We should ring a bell every time we hear the word reasonable throughout this bill, because again, that is our legislators and our regulators and the governor's office wanting to work with and really help to nurture the hemp economy here in the state of New York. Also, having licenses that last at least 3 years is very, very helpful. Some states only do 1-year licenses or 2-year licenses. So this is really great for us that these license periods shall be 3 years. Also, folks are going to have to maintain relevant information. The State Department of Ag will have to maintain relevant information regarding the land on which the hemp is produced. There will also must be a procedure for testing of hemp produced in the state for a delta-9 THC level using post-decarboxylation or other similarly reliable methods, or any other method authorized by the U.S. Department of Agriculture. I'm going to assume some people have some questions on this, so I will make sure that I tell you that it's true. New York will be testing for total THC. We're pretty sure the USDA is only going to tolerate testing for total THC, meaning that New York will be testing for the THCA, the acidic or non-intoxicating precursor to THC, as well as the THC, or should I say delta-9. So the THC is the intoxicating component of the cannabis plant, but we in New York will be testing both. So for total THC, for those of you who were thinking that they would only be testing for delta-9 and not testing for THCA, that is not the case. They will, unless the United States Department of Ag at some point changes its rule, which is not likely right out of the gate. They're still dealing with coming out of hysterical prohibition. They still have some THC hysteria. And so they probably are not going to change that anytime soon. And this language about using post-decarboxylation or other similarly reliable methods, keep in mind that that language is taken verbatim from the 2018 Farm Bill, which requires that type of testing. We'll see what or other similarly reliable methods means to the USDA. We're still learning what that means. Many people are hoping that means HPLC, high performance liquid chromatography. Having said that, HPLC will not decarboxylate the THCA. And so we think it's unlikely that they're going to allow that, but we'll see. Everything's in flux right now because that public comment period for the USDA, again, just ended. But this is what's in the law for the state of New York. And so we're not going to be able to deviate from this unless the USDA deviates from this, because our legislators in the governor's office, Axel Bernably in particular, were wise enough to add the language or any other method authorized by the United States Department of Agriculture. If by some miracle they authorize a more friendly testing methodology for farmers. Also, the commissioner is going to set procedures for effective disposal of hemp plants or products derived from hemp that are produced in violation of this article. Another amendment request that we made not only in New York, but as president of the HIA and as vice president of the U.S. Hemp Roundtable, we make these requests for every state. And again, New York deserves some kudos here. It has used the word disposal as opposed to destruction. Even the feds, the USDA, have used the word destruction in their interim final rule, despite the fact that the 2018 Farm Bill does not use the word destruction. The 2018 Farm Bill uses the word disposal, and of course there were lots of amendments and drafting that went into and crafting that language for the 2018 Farm Bill for a couple of years, and we were very keen on making sure that the Farm Bill said disposal, and it does. The USDA says destruction as opposed to disposal. We're not happy about that. And went into quite a bit of that in our public comments, but New York, disposal, and we love seeing that, and that was intentional, and everyone gets kudos for that, because disposal leaves everybody wide open from everything from sort of the least favorable disposal, which would be composting. I mean, that's useful, or biochar, and even pyrolysis would be really great. So pyrolysis would be taking the non-compliant hemp, putting it into, and they have many of these affordable pyrolysis machines, which would then give us a soil amendment. At the end, it would give fuel to the farm, pyrolysis, and perhaps even a substance, a carbon substance that we could do R&D, universities, aerospace, other nanotechnology industries that are here in the state that could use that leftover product of the world's most valuable biocellulose, which creates some of the most valuable carbon on the nanoscale. That hemp biocellulose is second only in surface area and strength to carbon nanotubes and graphite whiskers, which are cost prohibitive to perform even research and development on. And here we can get these materials from hemp biocellulose, particularly after it is heated to a high degree. So that would be a great form of disposal. And then we could get really creative with other methods of disposal. So we love that they kept this open, and that's very important. Moving on, they're going to also create procedures for sampling of hemp to verify that the hemp is not produced in violation. Now, the USDA's sampling plan is terrible, and it's in flux. They intentionally, and I realize I'm going back and forth, but I think it's very important for you to understand how the federal law dovetails with this. And when we say we really want this explained to you, there's no way to avoid explaining these pieces to you. And so understand that the interim final rule that the USDA filed was published in the Federal Register, but their testing and their sampling guidelines were not, and the USDA did do that on purpose, and that was helpful. So those are these separate documents that are in flux, and they're outside of the Federal Register. So we're hoping that they will make some big changes there, because their sampling is terrible, where you have to pick just the floral material from the very top of the plant, which is not at all representative of the whole plant, and which of course we know that the cannabinoids are concentrated in the flowering material at the top of the plant. So not very fair at all. Moving on, let's see here. Also, they will, the commissioner will create rules and regs on any other matters necessary or appropriate for the state to obtain approval from the USDA to assume primary regulatory authority over the production of hemp, and any other matters that they need in order to implement this program. Also, record keeping and reasonably necessary security measures. We love that. Again, reasonably necessary. Nothing crazy, like you have to install an 8-foot fence or you need to have video surveillance. So we're very grateful for that. as well as standards and practices or requirements for the growth and cultivation of the processing of hemp in connection with its cultivation. They can do all of those things, and again, all other rules. Now, if we get into section 509, and I realize in the interest of time here, we didn't do a practice run, so I'm kind of going through, and we very much wanted, and if you end up having questions, Aidan, as we go, please feel free to interrupt, because no doubt another person has that question, and then we'll eliminate some time at the end here. So as I continue to go on, the licensing and fees and requirements. Again, we're just in the ag log here. Nobody can do anything, grow, cultivate, process, produce, sell, or distribute it in hemp in the state unless authorized by the commissioner as part of an agricultural research pilot program established under this article, or grow, cultivate, and process hemp in, oh, sorry, where are we? We are here. Thank you for that, sir. We are here. Or grow, cultivate, and process hemp in connection with its growing and cultivation, or sell hemp plants or hemp seed unless licensed by the commissioner. Mere transportation, such as by common carrier or another entity or individual, does not constitute activity subject to licensing under this article. I think it's also important to understand, and I know some of this language can be confusing, but the Department of Ag is not going to be issuing processing licenses for hemp, as it has done in the past under the agricultural pilot program. Of course, there were these CBD processors, and those will be grandfathered in under the new law, as long as they're still performing the research in accordance with their plan and are in good standing and all of that. But it also had, the Department of Ag prior had given out licenses for processing of grain as well. And we always had complaints because we've never needed a license to process that fiber since the beginning of the history of the United States of America. Why would we start now? And of course, the Department of Ag has always stood down on that and not made those types of licenses requirements. But they will be, if you are going to be engaging in processing and manufacturing of grain for food, you will have to have all of the licenses required for any type of food handling or manufacturing of food. There won't be one specific to, because it's hemp processing. But of course, all of the other licenses for safety and quality that the Department of Ag gives out for the manufacturing of food, we will be subject to that. A hemp grower's license does not authorize the processing or retail sale of hemp for human consumption as defined in the hemp extract law, unless the hemp grower also possesses a cannabinoid hemp processor license or a cannabinoid hemp retailer license or any other license. So again, if you get this license from the Department of Ag to cultivate hemp, that's what you're allowed to do with it. You're allowed to cultivate hemp and process in connection with the cultivation of hemp, but you will not be allowed to process for cannabinoids or sell it or any of those other things. You will be allowed to grow it and process it in connection with its cultivation. Let's see, applications for licenses, authorizations, or a modification thereof as set out in the reg shall be in a form specified by the commissioner, accompanied by a reasonable application fee, which is what we love to see. And we also like to see that significant modifications as opposed to minor modifications will be subject to a fee. Again, that's very friendly and giving us some cover. There are some states that the most minor amendment causes a fee. For here in New York, it's going to be only significant modifications. And the commissioner may also assess a reasonable authorization or licensing fee established by regulation, scaled to cover the estimated or if known actual costs of inspections, regulatory testing, and other administrative expenses of the authorized or licensed activity, which fee shall be paid prior to the issuance of the license. So they're figuring out what all those fees are going to cost now. They're determining what the costs are going to be for inspections or field sampling, random inspections, regulatory testing. They'll get that all figured out. and that will be determined before the issue is issued, and that fee will be paid beforehand. This is an interesting one of having the applicant having to furnish evidence of his or her good moral character. And how does one do that? So you know that's not New York picking on hemp or picking on any form of cannabis. This need to furnish evidence of good moral character is actually a requirement for almost everything that the state licensing does. And in a way, it's sort of a catch-all. So if there is some shadiness going on that can't necessarily be proven, and I know this doesn't sound so great, but it is sort of a catch-all and a strategy and technique of our state and many other states, then they can fall back on this good moral character. So again, it's a strange requirement, one might think, but the reality is it's a requirement for almost all the licensing in the state, this evidence of good moral character, of not just individuals, but if it's an individual applying, then it's going to be around that person, but also if it's a partnership or if it's a corporation or a limited liability company, normally it would also be around those who have substantial responsibility for the license or authorized activities, and those including control of the entity, meaning principals, officers, or others exercising such control. And all of those names are going to have to be set forth in the application. Additionally, they're going to want folks to furnish evidence by answering questions in the application that they have enough experience, competency, and adequate facilities, equipment, process controls, testing capability, and security to grow, cultivate, and process the hemp in connection with its growing and cultivation. So they're not going to just be willy-nilly giving out these licenses to folks who are very gung-ho and enthusiastic but have no experience or competence or staff. They are going to reserve these licenses for folks who have a greater chance of success at the endeavor. And it is, frankly, a responsible thing to do. Hemp has its complexities. It's not the easiest thing in the world, and we don't want folks willy-nilly going out there and having a bad experience with the crop. Let's see, also, they're going to be able to, they will provide an application, a renewal fee, and a renewal application that they will get that renewal application out, I believe, let's see, a renewal application step. They'll get it out 90 days before you renew, and then you have to get it back 30 days before you renew. They, after due notice and opportunity, as we move into section 510 here, again, we love to see that. We love to see after due notice and an opportunity to be heard. Many states, once again, they don't include this protective language. This is the legislators and the governor's office having our backs here and saying, you will not be treated unfairly. You will not be treated in a hysterical manner. There will be due process. There will be an opportunity to be fair. We are in this together to nurture this promising hemp economy together, and we really like that. So, but after due notice and opportunity to be heard, if the commissioner is still going to decide to decline the application or the license, they certainly will. Let me move down here. And you see here again, from everything from good moral character or not having the necessary experience, all of those things that we just discussed. Also, they can suspend or revoke a license if after appropriate notice and opportunity to be heard, the applicant or licensee has failed to produce records or any other information that the commissioner is asking that is reasonably related to the administration or enforcement of this article. Again, ding, 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 reasonably related, as opposed to vague suspicion, or we want to use this against somebody because we have an alternate or an ulterior motive, and that does happen. In this state, it's not going to happen. The law is protecting us. Also, of course, they can suspend or revoke a license if it turns out that somebody has willfully failed to comply with any of the provisions of this articles or rules. Again, that's them having our back, willfully failed to comply. Many states don't say willfully, they just say failed to comply. This is New York State giving us a break, saying it has to be willful. Sometimes negligence is an intent, it's a state of mind. And so if we fail to comply, but make a better go at it, that's a different thing. It's willful failure that is going to be a problem. Meaning we did it on purpose. We did it knowingly. There was an intent not to comply. That's when the state of New York is compliance action plan if folks get in trouble, and we'll talk about that. And if the licensee fails to comply with its compliance action plan, that's in the next section, the hemp extract section. That's also another reason. And here we talk about in section 511 the proceedings to review. So everything will be done in accordance with the State Administrative Procedures Act. And then if we still don't like the ruling, then within 4 months of the date of service of that ruling, we can appeal it by filing a lawsuit against the Department of Ag in a court, following all of the rules of civil procedure for the state of New York. Transferability is where we are now. These licenses are not transferable at all, absent the written consent of the commissioner. Also, a license will become void by a change in ownership, substantial corporate change, or change of location or acreage grown without prior written approval of the commissioner. Here's another thing. So you can't do those things without the prior written approval of the commissioner. So none of these changes in ownership, because I guess the state needs to be monitoring good moral character, evidence of competency, all of those things. So the state is tracking it. Another thing that I like is the fact that it says the commissioner may promulgate rules and regulations allowing for certain types of changes in ownership without the need for prior written approval. So again, making it very clear that this is the law. Having said that, the commissioner can make other rules so that we can break this law lawfully, so to speak. And we love that. They're giving lots of options here. Access to criminal history, so you know there will be criminal background checks if demanded by the Department of Ag, including fingerprints, and their fees involved with any of those checks will be paid by the applicant, not the Department of Ag. And that would be fingerprints to an individual or the fingerprints for everybody involved, again, depending on if it's a limited liability company, a corporation, or a partnership. They're also going to, we're warned that if they want, they can send this to the FBI, the Federal Bureau of Investigation, also because they want to get an NCIC, a National Criminal History check as well. Also, records. They're going to, every licensee shall keep in such a form as the commissioner may direct records as required pursuant to rules and regs. So those record keeping requirements will be made. The aids to enforcement is our next section here. And I love, again, ding, 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 reasonable. All licensees shall be subject to reasonable inspection by the department, and a person who holds a license must make himself or herself available or an agent thereof to be present during that inspection. And I love this part as well. And this again, they went out of their way to put this in law. Most states do not do this. The department shall make reasonable accommodations so that ordinary business is not interrupted and safety and security measures are not compromised by the inspection. Really friendly language there, guys. Other states, they just want unfettered access, completely unannounced. They don't care if they're going to disrupt business, embarrass you publicly, ruin things, destroy your property. Here we have New York being so friendly to us. Okay, moving on. And the commissioner can also make other aids of enforcement that they may find necessary in order to enforce these rules. Compliance action plan. If the commissioner determines after notice and an opportunity to be heard, that the licensee has negligently violated a provision of this article or its rules or regs, that licensee will be required to comply with a corrective action plan established by the commissioner to correct the violation by a reasonable date. Again, reasonable date, and to periodically report to the commissioner. They're going to have to follow that compliance plan for a period of no less than the next 2 calendar years following the commencement date of the compliance plan. And here's the other thing. This compliance action plan is not subject to the research partners. This will only be subject to the agricultural commodity licenses, not our research partners. So penalties, in short, if your first penalty within the first 3 years, a fine of not more than $1,000. We're not saying it's $1,000, but it will be not more than. Your second fine within the first 3 years will be not more than $5,000. Your third fine within 3 years would be not more than $10,000. Remedies, as we move down here. The commissioner may institute such action at law and equity as it deems necessary to enforce compliance, and that's basically what remedies means. Anything that they need to be able to enforce compliance with any provision of this article or regs made under it, consistent with this chapter, as long as, of course, it's also in accordance with the civil practice law and rules. Hemp economic development, again, the New York State saying how much they support this burgeoning, promising industry, is that to the extent the commissioner believes it's necessary, the commissioner will consult with and cooperate with the New York State Urban Development Corporation with respect to the funding and support of research concerning hemp and businesses involving its growing, cultivation, and processing hemp for food, fiber, cannabinoid content, construction materials, and other uses, the whole thing. We love that they included this. We're talking about right hand and left hand and everybody working together to deliver on the promise of this crop for the state of New York and the nation. Also, hemp data and collection and best farming practices. So they're going to collect and publish data, and also they will be able to, and research concerning, among other things, growth, cultivation, production, and processing methods about hemp and products derived from hemp, with the New York State College of Agricultural and Life Sciences at Cornell. And I wanted to see if there was another school here. The bottom line here is that New York State is very much, again, wanting to get ahead of this, invest in this crop. And that means really meaningfully continuing research so that we can learn all that we need to about it. Soil, water, pesticides, the best methods. New York, we're all working together. The lawmakers, the regulators, the researchers, the farmers, the stakeholders, and of course farmers are our most important stakeholders, right? But we're all working together here. It's just such a great bill. And then, who cares about the severability? That's in every bill, which just basically says if for some reason part of this bill, it turns out, is unlawful or it can't be implemented, that shouldn't affect any other part of the bill. That's all that severability means. Now we get into where we're no longer amending, we're done now with the part of this bill that amended the Ag and Markets Law, and we're now into the part of this bill that amends the public health law. So now, instead of talking about the commissioner for the Department of Ag, we're now talking about the Department of Health. And with that, may you, sir, I'm just gonna ask Aidan to go ahead and read these. Let's talk about what, let's see, we are on page 7. Yep, and cannabinoid hemp in particular. I think everybody knows what a cannabinoid is, but this is an important one, guys. This is an important one. Cannabinoid.
All right, so cannabinoid hemp means any hemp and product processed or derived from hemp that is used for human consumption, provided that when such product is packaged or offered for retail sale to a consumer, it shall not have a concentration of more than 0.3% delta-9 tetrahydrocannabinol.
And you might get your panties in a wad, as I did when I first read this long ago, but that use, because I'm of course a very big protector of hemp grain and seed for human consumption. And so I see cannabinoid hemp and they're talking about hemp for human consumption. Oh my God, have they included grain in this? Because we don't want grain regulated the way folks are regulating extract right now. Good news, and that is, let's read the next definition because they dovetail one another. And I want to just again say, see this part here, used for human consumption? Now let's find out what used for human consumption means because it's specific to cannabinoids.
All right, used for human consumption means intended by the manufacturer or distributor to be A, used for human consumption for its cannabinoid content, or B, used in, on, or by the human body for its cannabinoid content.
So you'd think that they maybe would have put that in the definition of cannabinoid hemp, but they didn't. But I just want to assure you that cannabinoid hemp means any hemp and any product, processed, or derived from hemp that is used for human consumption for its cannabinoid content, or used in, on, or by the human body for its cannabinoid content. So this does not affect grain or any other part of the plant unless it's meant for cannabinoid content. And of course, hemp grain, hemp seed for human or animal ingestion is not a source at all of cannabinoids. Okay, now here's very interesting, guys. We have a new definition of hemp. Okay, this is not the same definition of hemp in the agricultural markets law. We have a separate definition of hemp for the public health law. Let's talk about that. Lay it on us, brother.
Okay. Hemp means the plant Cannabis sativa L and any part of such plant, including the seeds thereof and all derivatives, extracts, cannabinoids, isomers, acids, salts, and salts of isomers, whether growing or not, with a delta-9 tetrahydrocannabinol concentration, THC, if not more than 0.3% on a dry weight basis, shall not include medical marijuana as defined in subdivision 8 of section 3360 of this chapter.
So that's where our definition diverges, and because we had some bills, and Assemblywoman Lepardo was so fantastic in prime sponsoring. I had drafted amendments back in 2017 to our state definitions of industrial hemp, of concentrated cannabis, and of marijuana, because folks were still getting arrested for selling hemp extract, even though it was legal under state law. And it was very important in those, and those bills passed the Assembly, they just got gummed up in the Senate. So I'm loving seeing that we're finally altering and amending our definitions, and it was very important in those bills to make sure that when we talk about hemp, we say that it doesn't meet the definition of marijuana, and vice versa. So that's very important that they included so that there's no ambiguity. Hemp does not include medical marijuana. And once we have a definition for adult use marijuana, which we don't yet in the state of New York, probably they're going to amend the public health law definition so that it says in the future, it shall not include medical marijuana as defined in blah, 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 or adult use marijuana as defined in. Okay, here's another interesting one, guys, and I won't keep reading these or ask Aidan to, except when it's really important. And this is very interesting. Let's read the definition, Aidan, of hemp extract.
Hemp extract means all derivatives, extracts, cannabinoids, isomers, acids, salts, and salts of isomers derived from hemp, used or intended for human consumption for its cannabinoid content with a delta-9 tetrahydrocannabinol concentration of not more than an amount determined by the Department in Regulation. For the purpose of this article, hemp extract excludes any food ingredient, or food additive that is generally recognized as safe pursuant to federal law, or B, any hemp extract that is not used for human consumption. Such excluded substances shall not be regulated pursuant to provisions of this article, but are subject to other provisions of applicable state law, rules, and regulations.
Okay, now why is this significant? Why all of a sudden, instead of saying with the delta-9 THC concentration of not greater than 0.3%, we're now saying with the delta-9 THC concentration of not more than an amount determined by the Department in Regulation. Once again, This is our lawmakers, our regulators, and our governor's office. Thank you, Axel Bernalby and Assemblywoman Lupardo, giving us cover. Because those of you who are processing hemp for extract know that the in-process material, the raw crude, the legal hemp plant gets put into the machine, but on some level, marijuana comes out. So the legal hemp plant was biomass that did not contain greater than 0.3% on a dry weight basis, THC on a dry weight basis, but the crude oil, the unrefined oil that comes out, is often always spiking above that 0.3. And the state of New York is dealing with that head on and is going to create cover for us to be able to lawfully possess and potentially transport and potentially even sell to other licensed cannabinoid processors that material. So it's very strategic that the words not greater than 0.3% aren't included in the definition of hemp extract. Also, if God forbid, the FDA would come down with a heavy hand of God with finally making a final agency determination or final agency action around hemp extract, and I don't expect that they're going to work against us, they're just taking their sweet time working for us, then the state of New York would be able to say, hey, listen, we aren't trying to be compliant with the feds. We have our own state law here, and in ours, and they would revert back to state law protections, right? So this was just very, very clever. I also want to make sure, and it's important for us to understand this piece where they say, for purpose of this article, hemp extract excludes any food ingredient, or food additive that is grass, that is generally recognized as safe pursuant to federal law. Keep in mind, hulled hemp seeds, hemp protein powder, cold pressed hemp seed oil, those have all been given their first GRAS status thanks to Manitoba Harvest and Hemp Oil Canada by the FDA. That was granted on December 20th of 2019, the very day that the Farm Bill was signed by President Obama. So we're making very clear here that hemp extract has nothing to do with the grain and oil, because that is grass. And also they want to make sure they know that this is also, you're not going to be subject. Hemp extract does not include hemp extract that is not used for human consumption. So they're protecting us there. We know what a license means. Cannabinoid hemp processor license is a license granted by the department to process, extract, pack, or manufacture cannabinoid hemp or hemp extract into products, whether in its intermediate, meaning that raw crude oil, or final form used for human consumption. Processing means everything you can imagine that it means, but what it does not mean is, remember when we looked at that definition called processing in connection with cultivation? So processing for hemp extract does not include the processing that's in connection with cultivation, which is growing, cultivation, cloning, harvesting, drying, curing, grinding, or trimming, as long as that's authorized activity under the last law that we looked at, the agricultural law. So processing a hemp extract does not include that. Also, they want to make sure we know that mere transportation, again, such as common carrier or another entity or individual, processing doesn't include that either. So very good. Okay, we want to get going here because I've had you for an hour and you've all been very patient. And I know we want to get to some questions. So let me just move down quickly here. Again, rulemaking authority is being given to this time to the Department of Health when it comes to the Department of when it comes to hemp extract. And we see again, reasonable, why we love that. So reasonable administration and renewal fees are happening. They'll establish all of the same criteria essentially and more, and that's what we're going to look into here. Because the Department of Ag is not responsible for labeling, marketing, disease claims, all of those things. Whereas the Department of Health will be responsible and has been given authority to create those types of rules. Also keep in mind, and this is important, it's giving the Department of Health authorization to create provisions governing the modes, I'm trying to highlight this for you folks here, governing the modes and forms of administration of the hemp, including inhalation. So Many states are staying silent on inhalation. Others are banning it altogether. Others are giving it a free ride. And New York is wants to explore the safety around it, but clearly is making sure that there's belts and suspenders and guardrails there that will allow the department to move forward with those rules and regs if its research decides that it should. So that's very important. Also, it's going to be able to set up procedures to govern whether or not hemp and hemp extract and its derivatives and so on and so forth produced outside the state meet the standards and requirements within the state. Somebody has to make sure that that's happening, or we're going to have unfair competition, right? Products, hemp and products from outside of state will be able to come in with less scrutiny and less standards and take up shelf space here, when we here in New York are beholden to these higher standards. So New York is going to do its best to protect our New York stakeholders and farmers. Okay, the cannabinoid hemp processor license. Persons processing cannabinoid hemp or hemp extract used for human consumption, whether in intermediate or final form, will be required to obtain a hemp processor license. You're not processing for cannabinoids in the state of New York unless you have a hemp processor license. You're just not. And that's also the same thing with a seller. A cannabinoid hemp processor license authorizes one or more specific activities related to the processing of cannabinoid hemp into products for human consumption, whether in intermediate or final form, and the distribution or sale thereof by the licensee. Nothing herein shows. So if you have a cannabinoid processor license, you're also allowed to sell. You don't need a separate license to sell. We're going to talk about a separate license here, but if you are the licensed processor, you're good to be able to sell and distribute. And also they want to make sure you know that if you're processing things that aren't meant for cannabinoid content for human consumption, you're totally allowed to do that. Nothing in this article is preventing you from doing that. Moving on, let's see here, guys. I'm not quite sure where we're at. I'm trying to get my, I'm going by a paper copy, which is all marked up. So sometimes I lose my place here. But keeping in mind also, everything needs to be done within the state procedure, State Administrative Procedures Act. Nothing funky or hysterical or picking on us is happening here, and that's pretty important. Let's see. Also, they're going to be allowed to make rules around governing the advertising and marketing of cannabinoid hemp extract. So that is going to be interesting too. And I'm sure that what they're mostly concerned with are unlawful disease claims. And of course, they want to make sure that it's truth in labeling. All of those things need to happen under the Code of Federal Regulations for Current Good Manufacturing Practices. And as we'll see here, and I'll try to hurry up and get there, everything in this state, if it's for human consumption, is going to be made for cannabinoid hemp, which is the definition part of for human consumption, is going to have to be made as a baseline in strict accordance with 21 CFR 111, which is the Code of Federal Regulations for Current Good Manufacturing Practices for Dietary Supplements, or 21 CFR 117, which are the Code of Federal Regulations for Current Good Manufacturing Practices in Food, and we're going to have to follow the 21 CFR 101 labeling requirements. But keeping on here, let's now talk about this section, 33(9)(c), which is the cannabinoid hemp retailer license. So retailers selling cannabinoid hemp in final form to consumers within the state shall be required to obtain a cannabinoid hemp retailer license from the department. You will not be allowed to sell hemp extract at the retail level unless you have a license to do so. I also want to, and I love how here it's going to be a year or more on these licenses, but I think it's important for folks to understand that every retail location needs a license. Every we're in the hemp extract, so I don't want to belabor the point. What I'm talking about now is specific to hemp extract made for human consumption for its cannabinoid content. So every facility processing that you have is going to have a license. And then if every retail location you have, if you're applying for a retailer location, needs to have a license. Good news, you only have to fill out the one application, but you're going to have to give all the information for each separate facility or each separate retail location on that one application. Let's see here, moving on. And what doesn't apply to hemp, and none of this, as we say before, none of this article applies to hemp that is not meant for human consumption. And human consumption has to do with the cannabinoid content. I like this part. Let's move on to section 6 here. I'm trying to get to the right page, guys. 9, section 6. Anybody, and this is the grandfathering part, so anybody on the phone who has an authorized a CBD processor research partner agreement, good news for you. To the extent you're holding that active research partner agreement with the department, and provided that you are still actively performing research pursuant to that agreement and you're able to demonstrate compliance with this article, with the new law, as determined by the department, then you will get grandfathered in. You will automatically get this license. There may very well be a fee. I'm not saying that there won't be a fee, but the good news is you'll be getting grandfathered in there. Let's see. I also think it's important to know, and I don't see it here, but keep in mind that no cannabinoid licenses of any kind, whether it's the cannabinoid processor or the cannabinoid retailer, and those are the only 2 licenses that there are under this bill, will be granted to folks under 18 years of age. So folks are going to have to be at least 18 years of age. The type of information that they're going to request on the license is basically, and that's this section here, guys, is the same as the grower license. So you're going to have to demonstrate and furnish evidence of good moral character, like with all licenses in the state, furnish evidence of competency, facilities, funding, all of those things, security, all of that. Let's see. Moving on here, guys, getting to some more good stuff. Again, lots of uses of the word reasonable. Reasonable amounts of information, reasonable amount for the fees. Let's talk about this, because this is very important. If there be any change after the filing of the application or granting or modification or renewal of the license in any of the material facts required to be set forth in the application, a supplemental statement giving notice of such change duly verified shall be filed with the department within 10 days after such change. So if there's a change, you must notify the department within 10 days after that change, and failure to do so, and I love this part, if willful and deliberate, may be grounds for revocation of the license. So mistakes happen, innocent mistakes happen. But if it's willful and deliberate, they may take away your license. Again, keep in mind, the state is under no obligation to include this type of protected, helpful language in law or in regulation, and they have done that intentionally on purpose. Thank you so much, Assemblywoman Lopardo, and thank you, Axel Barnaby of the Governor's Office. Then we get into the fees. We're talking about reasonable fees to be set here, but what is interesting, and I'll be anxious to hear this, and we know that, again, they do want to be reasonable, but it looks like, and I'm trying to highlight this for you guys, they're going to set fees potentially based on, when we say may and not shall, such fee may be based on the activities permitted by the license, the amount of cannabinoid hemp or hemp extract to be processed or extracted by the licensee, the gross annual receipts of the licensee from the previous license period, or any other factors reasonably deemed appropriate by the department. So I always get a little scared with that, because we start to look at, sliding scale fees and So if you have a $10 million gross receipts the previous year, what is the state going to want for a chunk of that the next year? So there's always a little bit of concern here, but they have put some checks and balances and guardrails in, again, by making sure that they use the word reasonable license fee, other factors reasonably deemed necessary. So I don't want to get us too paranoid, but it's important to me that we point out that those are the factors that they're considering as they set these fees are. Selection criteria, again, good moral character, competency of if you're an individual applicant, of you, or of those in control or reasonably responsible, or the officers and so on, principals, officers, or others in control on that license. Let's see. Let's keep moving on here. And then they talk about the form of license, the different things they're going to ask. It's the same as most states, and certainly almost the same as the questions they asked in the research. They won't be asking for a research goal. Obviously, this is outside of the research plan, but you know, basic stuff: name, address, activities, the land, the buildings, the GPS coordinates, and they'll give us a license number on the license, and anything else that the commissioner of the Department of Health deems necessary. So those are the items that will be on the license, a bit of what is asked for on the application. Again, here, in terms of transferability, the license is not transferable, and that's 3398J, is not transferable without the written consent of the commissioner. The license can be amended to add or delete for permitted activities. The license shall become void by a change of ownership, the same thing, or substantial corporate change if there wasn't prior written consent of the commissioner, and the commissioner of the Department of Health is also being granted authority to sort of break their own rule. They may find circumstances where that written authorization is not necessary. And basically the same thing, the same rights as before for the granting, suspending, or revoking. After due notice and an opportunity to be heard, again, really protecting the process. If they discover these willful failures or other things, they will have the right to suspend or revoke your license. I don't want to belabor the point because it's basically the exact same thing that the rights of the Department of Ag has in terms of granting, suspending, and revoking. Reasonable, and you'll have an opportunity to be heard. And of course, there's again, as we get down to section 5, continuing that there has to be a willful failure to comply. They put that language in there to make it fair to us. Record keeping and record tracking, same thing. The Department of Health is going to be able to come up with rules for that in the same way the Department of Ag was. Let's get into the label warnings here, and we're getting to the end. This is, now I want you to know that what was put in law as to what may be required on the label is important for us to pay attention to, but the rules and regs may add a whole lot more. It's just because they're saying this is what the commissioner for the Department of Health may require on the label, and they may require a bunch of other stuff too. So essentially what they may require is to establish a code or a QR code that will lead folks to QR code on the label that will lead folks to various information. They're going to want serving sizes on the label or dosages. Again, we try not to use the word dose when we're talking about dietary supplements. Dosages come with drugs and medicines, not dietary supplements and food, but I digress. They're going to want the serving sizes on there. Also, they are going to want the active cannabinoid concentration per serving size. So how many milligrams of what per serving size, and we'll have to say what that is, the number of the servings per container, and if not from the United States, the growing region, state, or country of origin, if it's not from the United States. They also say that such rules and regulations, getting down here for you, may require an appropriate fact panel that incorporates data. That was another amendment request that we had. They'd asked for a nutrition fact panel, but the reality is to follow the law of the Code of Federal Regulations. If you're marketing and manufacturing a dietary supplement, you have to have a supplement fact panel by law. If you're marketing food or beverage, you would have a nutrition fact panel. By the way, I think what you're going to notice here is that this particular law has stayed silent on whether or not we're allowing food and beverage, and that also cannabinoids to be added. I say cannabinoids, I could say CBD all day, guys, but we already know there's CBG on the market. I've got a CBN vape pen. You know, we're beyond CBD at this point. For this conversation particularly. If we get into an FDA conversation, that's another story because CBD has been approved as a drug. But in terms of cannabinoids, if you're wanting to add cannabinoids to food and beverage, this bill is silent on that. So let's see how it goes. They didn't put a straight up prohibition on it the way they did in the last bill, allowing only hemp sown in New York for hemp beverages, but no hemp food, and only allowing certain things. They're keeping it silent, but they're doing that on purpose to leave options for us. So the truth and the reality will unfold over time. But I wanted to make sure that we knew that. Oh, that's where we get the fact panel. Okay, moving on. Also, the packaging, sale, or possession of products derived from cannabinoid hemp or hemp extract used for hemp consumption, not labeled or offered in conformity with regulations under this section, shall be grounds for the seizure or quarantine of the product, as well as the imposition of a civil penalty against the processor or retailer, and the suspension, revocation, or cancellation. So understand that you're going to have to conform with these labeling requirements, or you will be subject to, and by the way, it says shall be, not maybe. It says shall be grounds for seizure or quarantine of the product. And we want that, guys. We want these standardizations. We want truth in labeling. We want to make sure that we are being transparent with the consumer. And most importantly, we don't want the products coming in from out of state that don't meet these requirements to be allowed to compete with New York stakeholders for shelf space, right? So we want these to be enforced because we particularly want to protect our New York farmers, right? And our New York industry stakeholders. So we're all going to have to follow the law for the labeling, which is very important. And by the way, it's completely key with the FDA. So this is not really saying anything other than what the FDA is saying. It's just that the Department of Health is going to be able to promulgate rules that does the FDA's job for them. So around warnings that the FDA isn't dealing with that are specific to cannabinoids, potentially around potency that the FDA isn't dealing with specific to cannabinoids, and those will become additional labeling requirements in addition to the Code of Federal Regulations for that. Okay, moving on very quickly. Also, they talk about in this section here that they are going to be able to prescribe the type of containers and the sizes of those containers and the quantities within those containers, which I did find interesting, but it may be a way that they're trying to control stuff coming in and out of the state as well. So there are going to be rules around that. There also, we talk about pesticides. New York, again, is very concerned with quality control and wants to be, and safety, and wants to be the gold standard. And so they talk about processors taking such steps necessary to ensure that their cannabinoid hemp or hemp extract used in their operation has only been grown with pesticides that are registered by the New York Department of Environmental Conservation, or that specifically meet the US EPA, Environmental Protections Agency's registration exemption criteria for a minimum risk, used in compliance with rules, regs, standards, and guidelines issued by the New York Department of Environmental Conservation for pesticides. So we're conscious of that, folks, and there is a law around it. Here's where they make very clear, once again, that if you are all cannabinoid hemp extract and products derived therefrom for human consumption need to be extracted and processed in accordance with good manufacturing processes pursuant to Part 117 or 111 of 21 CFR. That's Title 21 of the Code of Federal Regulations, as may be defined modified and decided upon by the commissioner in rules of regulations. So they may very well modify them, and they're going to, I believe. They're going to modify them to address the issues that are specific to hemp extract and cannabinoids that the FDA has thus far failed to address. New York State picking up the slack. Okay, here, as necessary to protect human health, the department shall have the authority to regulate and prohibit specific ingredients, excipients, or methods used in processing hemp. And maybe this means a solvent, such as butane or hexane. We'll see. But and they also may be allowed to prohibit or expressly allow certain products or product classes derived from hemp. Or hemp extract to be processed. So lots of authority here for the Department of Health to do, frankly, the FDA's job that it is not yet doing for this industry that our federal legislators have so gloriously opened up for the entire nation. Okay, lab testing. The bottom line here is that we're all going to have to find independent labs, but the commissioner shall, not may, the commissioner is going to and must establish the necessary qualifications or certifications required for such labs to be used by the licensee. New York hemp product, the commissioner may establish and adopt official grades and standards for cannabinoid hemp extract and products derived therefrom, as he or she may deem advisable, which are produced for sale in the state, and from time to time may amend them. We love that. This is really New York, again, understanding that it's taking a laboring oar. We don't have a lot of standards and grades, even throughout the entire world in other countries that have not had their development arrested by prohibition, or that are still in some form of prohibition, but that have been regulating the crop as an agricultural commodity for decades. There still aren't grades and standards, so we're all working together. I'm also the vice president of the U.S. Hemp Authority, which is created standards for CGMP. We're working with ASTM. We're working with other governmental bodies from international to Fed to state level, all of us trying to work together for standards and grades. Almost at the end here, guys. Penalties are the same thing as before with the Department of Ag. So your first violation within the first 3 years will be a fine of not more than $1 grand. Second violation within the first 3 years, a fine not more than $5 grand. And your third violation within 3 years, thank you, sweetie, is not more than 10 grand. Same as before. This is interesting and unique. That wasn't in the other law, and that's the hemp work group. There will be a hemp work group that may be established by the commissioner for the Department of Health. They would work with the commissioner for the Department of Ag to create this work group. And this is another one of our amendments that was granted. The original language did not include trade associations as mandatory members of this potential work group, and that was added in, and we really appreciate that. That was Assemblywoman Donna Lopardo who granted that amendment of ours. So the work group would be made up, they would appoint, the Department of Ag and the Department of Health would appoint the work group composed of growers, researchers, producers, processors, manufacturers, and trade associations to make recommendations for the hemp and cannabinoid programs, state and federal policies and policy initiatives, and opportunities for the promotion and marketing of hemp. That's very important. Many states have these work groups, and they're very, very valuable. California, Kentucky, Colorado, incredibly hardworking work groups that are really rolling their sleeves up in conjunction with our lawmakers and regulators. Prohibitions, except as authorized by the U.S. Food and Drug Administration, the FDA, the processing of cannabinoid hemp or hemp extract used for human consumption, meaning for its cannabinoid content, is prohibited within the state unless the processor has a license under this article. Cannabinoid hemp and hemp extract used for human consumption and grown or processed outside the state shall not be distributed or sold at retail here unless they meet all those standards established. And that's what we want, guys. Additionally, prohibitions, the retail sale of cannabinoid hemp is prohibited in this state unless the retailer is licensed under this article. By the way, I asked Axel a question, and it still remains to be seen, but the best guess was the logical one. And that is, I said, what about sort of traveling salesmen? There are some folks where they don't have a retail location, but they sell at the retail levels. Old school, we've got a lot of them in New York that just pound the pavement, door-to-door salesmen. In that case, they would still have to file for a license, but their retail location would essentially be wherever it is that they store the products that they sell as they go door to door. So I just wanted to make sure folks knew that. Finally, because we already know about the severability, although I'll get to the finally part when we talk about the last section, but special use permits, and that's really important. The commissioner is going to have the authority, the Department of Health, to issue temporary permits for carrying out various activities related to cannabinoid hemp now, and they'll set reasonable fees for those special use permits, and that might be for events, right? Or a meal, infusing in a meal, perhaps there might be special permits for that. We hope that food and beverage is just going to be allowed, but it may turn into a special use permit. And there may be one for a distributor, who knows, as opposed to retail. That could get interesting, but they've kept it wide open for any needs that may come up. Again, the severability. And finally, in this law, they have amended our state definition of marijuana. Thank God, finally. Again, we had those bills in 2017. And it almost matches the new definition for marijuana from the feds, in that it says the term marijuana does not include, and it keeps the old language, mature stalks, sterilized seeds, so on and so forth, as well as the term marijuana in our state does not include hemp as defined in the last law, as defined in ag and markets. It also does not include cannabinoid hemp as defined in this section, and it also does not include hemp extract as defined in this section. So all of that has been formally removed from the definition of marijuana, which was very, very necessary, because folks were getting arrested for selling hemp extract. I'm not kidding. I was pulled in, and that's what started the whole bills, and why Donna, Assemblywoman Lupardo, was so agreeable to supporting them, was because it was no one's intent for folks to get arrested for selling concentrated cannabis when it was just CBD oil. But the definition of our state for marijuana was making that happen, was equating hemp extract with concentrated cannabis and causing felony prosecutions. Okay, what are the enactment dates here? And anyone who wants to stay on, you're welcome to. Aidan and I are happy to answer any questions. I know we've had you here for a long time. It's confusing when the enactment dates of the different parts of the bill are. So it's important for us to tell you that the first part, the Ag and Markets Bill, not anything to do with hemp extract, that first section that we were talking about, that goes into effect on March 8th of this year. That's the enactment date for our agricultural parts. With regard to the hemp extract law, that is going to go into effect on May 1st of 2020, May 1st of this year, except for a couple provisions. The following provisions of the hemp extract law will not go into effect until January 1 of 2021, practically a year from now. And that is the provisions for the cannabinoid hemp processor license. So we're going to take a while to get those regs written and get that application out. Also, the cannabinoid hemp retailer license, a while to get those regs written and get that application out. And then the prohibitions section. So the section 3398B, section 3398C, and section 3398S of the hemp extract law, none of that goes into effect or will be enacted until January 1 of 2021. That was a heck of a mouthful for me. I think that was a lot for folks too. Shall I stop sharing too?
Yeah. Thank you very much for everybody that
3 hours.
Yeah, 3 hours. We've just hit the 3 hour mark. 3 hours and 1 minute.
You're diehards.
So yeah, great. Thank you very much for participating. If any of you are not members of the NYHIA, please join. As Joy said, it's very simple. You go to joinhemp.org, and when you go through the different components of it, there's one section that asks you to check off a chapter that you want to be a part of. Make sure you check off the New York chapter, or you will not actually be a part of it. You will not have voting rights, and you will not get your dues. So we very much appreciate all that you're doing, and we look forward to continuing to grow this hemp industry with you.
And we're excited to deliver more webinars on all kinds of different subjects. And I promise that we won't always, I'll stay here all night because I just love hemp, and so will Aidan, but we don't want to do that to you guys. So hopefully they'll be a little more efficient for your sake in the future. And for everyone who stayed on for 3 hours, you rock, people. Let's work together.
This is great.
Thank you. Thanks, everyone.
Everybody's saying great job. Yeah, thank you very much. Everybody have a wonderful evening.